We're next on the matter of Jeremy Azora versus Christina Sewell.
Can you hear me?
I can now, yes, sir. All
Okay,
right, so
thank
this
you.
was referred to the court based on a ex parte order granting temporary sole legal and physical custody to the defendant. So, Ms. Sewell, what do you wish to say about this matter?
I just wanted to let the courts know that with everything that's been going on, I actually just filed another FOIA report to get the full concluded narrative from the police. And as of right now, I just obtained that information yesterday. What I would have to say is I would like to try to get a hearing to present some evidence, because there is a lot of alarming red flag information that is in this report.
Okay, so you're asking for the ex parte order to continue pending a hearing?
Because today we're stepping inside a tense courtroom battle between Jeremy Azora and Christina Sue. From the very start, you can feel the tension as the judge opens the case and Christina takes the floor. She's determined to prove that something serious is being overlooked, claiming alarming red flags in a police report she just received. She asks the court for a hearing to present this new evidence, setting off a chain of events that will test truth, credibility, and control. This is just the calm before the real storm breaks inside this courtroom.
Yes.
Okay. Mr. Azura, what would you like to say?
I mean, that's fine. She's well within her rights to do that. I would think that that would fall under a change of custody, change of circumstance. That would be separate from the ex parte today. This was, the investigation is closed. I do have the report. I also sent it to front of the court, I believe this morning, to Shasta's email. So I believe I did get a confirmation that it was in the file. But the ex parte was ordered pending this investigation. The investigation is now closed. There's been no findings of any criminal activity or wrongdoing. I mean, she's well within her rights to file a separate motion for a change of custody, change of circumstance, and go through a hearing that route. That's fine. But in terms of what I was thought this hearing was the ex parte to be in order pending this investigation. The investigation is now closed, and there's been no criminal findings.
Did you file an objection to the ex parte order?
I did not.
Okay. So when an ex parte order is issued, a party has a right to file an objection, and then the matter goes before the judge who made the decision on the ex parte order. In this matter, it looks like the judge granted the ex parte and then simply referred it back to the court for a follow-up.
Correct, which was pending the outcome of the investigation.
So,
Your Honor,
yes.
in regards to his email, I did indicate to him that the email was received, but that information was for friend of the court records only, and how to present that to the court if he seeks to do that.
And I don't know if your objection period may have run now to object to the order itself.
As the discussion unfolds, Jeremy steps in with a composed but firm tone. He insists the investigation is over and cleared him of any wrongdoing. The judge presses for clarity. Did anyone object to the ex parte order? Jeremy admits he didn't, believing the case was simple and straightforward. But the court quickly reminds everyone how procedure really works, creating a sense of quiet tension. This is where the balance between legal process and raw emotion starts to show. Each word measured, but the stakes couldn't be higher.
If done that, we'd be on a little bit of a different track. So this matter was simply sent to be referred back. Right now, that order is still in place.
Well, the reason I didn't file because it was pretty much cut and dry. I mean, the order was put into effect pending the investigation. So now that the investigation's closed, I just kind of, I don't want to, I guess, assume that, you know, it would go nowhere because the investigation was still open.
Sure, but I can't make those changes without taking testimony, and we do not have, obviously, the time for that on today's docket. I would have to set up for a separate evidentiary hearing. I would also have to do an interview of the child, I believe, because I'd have to address best interest factors. Obviously, if parenting time is being withheld unjustly, as indicated in the ex parte order, there would be the potential of make-up parenting time. So if this investigation is closed and there are no good cause to withhold your parenting time, I mean, that's a potential issue. So, I mean, I think the court's kind of in a rough.
I do believe that this is. I'm sorry.
I'm in kind of a rough spot when this is the way this is scheduled and handled. So, Ms. Sewell, you've received the documents, and there's no ongoing investigation at this point.
There was nothing criminally found, but in the report, there are very red flag alarming findings
Objection to that.
found in.
So, Mr. Missouri, you're going to speak when it's your turn to speak, and Ms. Sewell's going to speak when it's her turn to speak. She was not interrupting you, okay? All right, go ahead, ma'am.
Due to the nature of this claim, there's a lot of evidence that would prove that he is not fit to take back a minor child. With the new narrative, findings from the disposition from the police, the interview that the cop had with Jeremy when he picked up his devices, and the findings of what was found with text messages, folder files being deleted, and initiating these conversations with what is listed as 10 plus female women on Facebook. So this wasn't just a one-time thing.
Atmosphere changes completely. Christina's emotions rise as she claims there are shocking findings in the police report. Deleted messages, hidden folders, and disturbing interactions with multiple women. Jeremy objects, the judge steps in, and for a moment the courtroom feels like it's on the edge of breaking order. Christina insists her child isn't safe, while the judge struggles to keep the focus on evidence, not emotion. This is where accusation meets authority, and the entire case takes a dramatic turn.
I mean, the issue is you believe that there are things going on at this time that put your child in danger during parenting time with dad?
Yes.
So then you are requesting a hearing on whether or what his parenting time should ultimately be. Are you thinking he should have no parenting time at this time, ma'am?
I am thinking that too, and in the best interest of the child. I'm sorry.
So your request is that he have no parenting time?
I am requesting that, and only solely based on Liliana, who's the child. She does not want to see her father or talk to him. I have tried to get her to have phone conversations with him. She's had 2, and both of them did not go as well as what I would think a daughter-father relationship would go.
Mr. Azura,
Emotions hit a boiling point as Christina reveals her daughter refuses to see or speak to her father. Jeremy's response is raw and frustrated. He says he's been shut out, that his daughter is confused after months of no contact. He claims the mother has been influencing things for years, trying to push him out of his child's life. You can feel the heartbreak behind every word, as a father fights not just a legal battle but a personal one to stay in his daughter's world. The truth now feels more blurred than ever.
what would you like to say?
Well, as far as the phone conversations goes, I try on a consistent basis, and all I get met with is she doesn't want to talk. She doesn't want to talk. And the two conversations I did have with her, yeah, maybe they didn't go as well as could be, but there was still communication. And, you know, my daughter is 9. She's confused. She's been without her dad for, you know, the past 2.5 months. There's been no problem for the past 9 years, but all of a sudden it's, yeah, there's a problem. And the fact that she can't talk to me, I can't talk with her, I can't communicate with her. And it's not just me, you know, my mom, you know, Liliana's grandma, my sister, we've all been locked out. And I don't know if this is my daughter telling that she doesn't want to talk or mom encouraging it. Because, you know, mom's been, for the past 9 years since day one, she's tried to find any angle. I breathe wrong and she wants me out of the picture. And even on this, she states, made the statement of evidence. There is no evidence. That's why the investigation's closed. There is no evidence. It's a matter of opinion and speculation and may or may not situation. It's not of any type of facts. I mean, so
Right,
yes,
so-
it has fractured. I'm sorry.
All right, here's what we're gonna do. I'm gonna set the matter for a hearing. There are other things that can be done in the meantime too, but the order indicates that parenting time is suspended without prejudice, subject to makeup time in the future, if deemed appropriate, until completion of the investigation of plaintiff and a referee hearing on the same allegations. So I can't make a guess as to what the judge was, if it should stop, if there was a completion of an investigation without charges or not. I don't know from what's written if that was the intent. So I'm not in a position to cancel the ex parte order. You could file, sir, if you felt appropriate, your own ex parte request to reinstate your parenting time because your investigation is closed, if that is the case, and provide that proof. And maybe that's what the judge's thoughts were when issuing the ex parte order. So that is one way you could take it. And then but it also says, and a referee hearing on the same allegations. So I'm going to schedule a hearing for December 10th at 11 o'clock, unless one of you has a conflict with that date.
Give me 1 second, please, Your Honor. December 10th, you said, at 11?
Yes.
That would work for me, Your Honor.
Sewell, are you available that date?
I am available that day.
All right, so that's a in-person hearing, so you guys will be here in person. If you intend to call any witnesses or provide any exhibits, you need to file a witness and exhibit list. That information will also be provided in the notice that is sent to you. Given the child's age, there would be a child interview. So the child should be here at 10:45 that day for the preference interview. Obviously, the child cannot stay in the courtroom during the hearing, so it's appropriate to have somebody available to either take the child home or back to school. Any questions, Ms. Sewell?
No question. Thank you.
Any questions, Mr. Azora?
Yes, is it possible to have some sort of, like our daughter be, have a meeting with a counselor, like 3 sessions to talk with a counselor? Because if this is severe and you know, our daughter goes from 9 years
I'm
of being with dad to
order that without testimony, but certainly the parties can agree to have the child participate in counseling. If you guys don't come to an agreement with that, that's certainly an argument you can make at the next hearing.
Okay, thank you.
All right, thank you both for appearing. You're all set.
There will be a full hearing in December, and the child will be interviewed before it. Both parents must prepare evidence, and Jeremy asks if their daughter can see a counselor before the hearing. The judge allows it if both agree, showing there's still hope for resolution. But as the case closes, nothing feels settled. just a temporary pause before the next chapter. This courtroom story is far from over. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next one.